Divorce Talk Radio does not give legal advice, neither does it reflect the views of Rockford College. To obtain legal advice, you need to retain an attorney in your own jurisdiction.
Good evening, folks, and welcome to Divorce Talk Radio. This is attorney Brad Tengler here in the studio with attorney Maureen McFarland, an assistant attorney general who helps those receiving public aid also obtain child support.
And specifically, Maureen, who do you work for?
My boss is Lisa Madigan, so I'm an assistant attorney general. And as everyone knows, Lisa Madigan is the attorney general for the state of Illinois. And I have one client, and my client is the Illinois Department of Healthcare and Family Services, better known as Public Aid. In our office, we call them HFS.
And how does the Attorney General, what is the connection between the Attorney General and child support?
The Attorney General represents HFS, who then is the one that files and requests us to represent them on child support issues. So we are their lawyer.
And when I think of people getting child support, you know, obviously I represent people in court for child support purposes, whether defending or advocating for them. I'm representing individuals. How does the Attorney General get involved through public aid to assist people with child support?
What happens is a person will go to public aid, and they will either they'll receive some type of assistance that then automatically requires HFS to go after the other parent for child support because of the type of the assistance they're getting, or the person will actually come to public aid and say, will you help me get child support? HFS then interviews them, does an extensive packet they have to fill out and do all these things, and then they actually will send my office the petition and the information with it. I review the petition and then bring it to court.
So the Attorney General is not representing, say, visiting parents from whom the custodial parent is petitioning child support for, correct?
Correct.
You are representing or intervening on behalf of custodial parents who need child support.
Yeah, and I think the biggest misconception is that we do not represent the individual. We represent HFS.
And what's the difference there? What does that mean?
It's a huge difference. For example, in the exact same case, we can file a petition asking for child support for the custodial parent who happens to be the mom. 4 months later, we could be asked to file to reduce child support on behalf of the father because he's paying too much. Because we don't represent her and we don't represent him. We represent the interests of Illinois. And Illinois' interest is that we recoup the money that we're giving these families because they're on public aid, but it's also to make sure that these orders that are in place for child support are legally accurate, and that means if I'm collecting more than the statutory amount of child support from you, and you come to HFS, public aid, and you tell us this, well, then we're going to file to reduce because we want the statutorily correct amount being taken from your paycheck. So
I did not realize that. I thought that DHS only intervened on behalf of parents who are functioning as custodial parents.
Nope.
Another question in relationship to that. Does the Department of Healthcare and Family Services, do they file petitions for custody or visitation rights, anything like that?
We do absolutely nothing with custody or visitation. And in fact, we follow the public aid code. So if you came to me, Brad, and you said that the child resides with you, but someone else actually has legal custody on paper, I can still file for child support for you because public aid does not require that there actually be an established custody order. In fact, you don't even have to have necessarily custody. If you can prove the child is placed with you, residing with you, we can get child support for you. So you'll see that where custody might be with a mother, but the child is clearly living with the grandma, then we can file on behalf of the grandma for child support.
And can you do that in family court, or can that only take place in probate court?
No, we do that in family court because we do not care who has custody. So grandma, for some purposes, she may need to go to probate court to get actual, some type of legal custody to enroll the child for this or that. But a lot of times you'll see the grandma is already getting public aid. She's getting a medical card for this child. The school says the child lives there, and she doesn't have any type of legal custody. She doesn't have an order that shows she has guardianship or anything. We don't care. Because there's proof the child's living with her, then we'll go after the mother and the father for child support.
Wow. Okay. That I did not know. Let's take a step back and talk a little bit about process. So we have a mother who has a 6-month infant. She is desperately in need of child support. How does that process begin? Does the department contact her? Does she contact the department? How does it work?
If she is collecting what's called Temporary Assistance for Needy Families, or TANF, that's actual cash. It's an actual amount of just cash money that a person receives because they meet these requirements.
And what are some of the requirements?
The requirements are that you are either make absolutely no money at all, or the amount of money you make is way below the poverty line.
Sure.
That you have children. I don't think you can collect TANF if you don't have children. So you have to have at least one child residing with you. And then once you qualify and you receive this, then HFS is required by law, by the Public Aid Code, to then have this person come to the office and cooperate, try to find out who the father is if he hasn't signed a voluntary acknowledgement of paternity. We have to, she cooperates and does a paternity affidavit saying who she thinks the father is, or all one for each person. And then she has to cooperate with reviewing the petition, trying to locate that parent. She has to participate with naming her children, giving their social security numbers, their, whatever child the infant that you're using, on the petition. And she has to fill out all that paperwork. She has to sign it. She has to return it. And then it'll come to court. If she refuses to cooperate, then an actual case manager that works at HFS, that's the one that's trying to work with her, can actually sign the petition anyway, and then they'll cut her benefits.
Interesting. So she must cooperate in order to continue to receive those TANF benefits. Yep. Would that include the medical card, benefits like that?
No, it's just that it depends. If the system works correctly, which is a big if,
sure,
she would get cut from her benefits. Number one, they would do the cash. Cash assistance would get cut. A lot of times you don't see it as much with the medical card or food stamps and things like that. They'll continue to receive those things. But I have had people that are non-cooperative and they were only on the medical card.
And why would people be uncooperative? Wouldn't they want child support?
Because there's a whole host of reasons. Like some of them feel the person is abusive and they don't want them around, and they're afraid that if they were to contact them or make them come to court about child support, they try to be in the child's life again. Some of them are on cash assistance and receiving help from the father anyway, or the mother. And where you get that is once the child support is ordered, that's money going to the government. It's not going to them. So that person will tell them, hey, if you do this, I'm not going to give you money anymore.
So when a child support is entered based on a petition filed by the department, that money does not go to the custodial parent. It goes back to the department to basically refund them for monies that they are spending for TANF.
A certain percentage of it goes to the custodial parent, and then the rest of it will go to the gov.
What's the percentage?
It's $50, and I think it's the first $50 goes to Illinois, and then the rest goes to the custodial parent, or it's the other way around. But I'm pretty positive it's the first $50 goes to Illinois.
When you say the first $50, you mean within a week or a month period of time?
Yeah, so if I'm ordered to pay $60 a week, 50 of it goes to Illinois, 10 of it goes to the mother.
What if the father does not, or the visiting parent, does not work at a job where the money can be garnished from his wages? Then how does the department get the money?
Because they're court ordered to pay through the state disbursement unit.
I see.
And the state disbursement unit is completely separate of HFS. It's its own governmental entity. However, that would be another place, though, where if there were issues with the state's disbursement unit, we would come in and represent them, too.
I see.
But even though they're separate entities. So they pay through the state disbursement unit, the money's processed, and then paid out to the parent or given to HFS, depending on what's owed to Illinois, what's owed to the custodial parent.
So you just talked about custodial parents who are receiving assistance from the state of Illinois through TANF or something like that, that the department files a petition on behalf of. Are there non-assisted custodial parents that the department assists that helps?
Yeah, all the time.
Okay, and how does that work? Does the department contact them, or how does it work?
They have to contact the department. And so you'll see that with, like, when I was in private practice, we would do a divorce, and, a heated issue would be child support. So you see lawyers just reserve that issue, or they don't address that issue, and then
We never do that.
they'll tell their client to now go to HFS and ask them to help you get child support, because they're not. A good lawyer would tell the person to do that, because that is something then they don't legally, have to continue to pay their lawyer to do.
Sure.
So, it's a way for them to save money, and also a lot of ways it's a way to get a divorce done and over with. And if they still need child support afterwards, that they can then go to HFS and ask them to help them.
Will HFS help any person that comes to them, or do they have to meet some kind of income requirement? How does that work?
They'll help anyone.
So even if you're making $100,000 a year, they will help you get child support?
They will help you. Mm-hmm. Yep. Like, I have people, like right now, I have a guy that makes just a total buttload of money, and the guy will not pay his child support. And we intervened in their divorce case and then filed a contempt petition to help her recover her money. And the reason for that is because the state disbursement unit is a governmental is a entity, and HFS is an entity that have to hand in every year reports to the federal government to show how well their program is working. So they're looking at the outstanding money that's not being collected, regardless of whether that is an actual HFS case, or is it just a case that's going through the state disbursement unit. Both of those entities, though, have to show that they're, working well, right? And that a lot of times a high balance.
Sure.
You'll see it more with those, like contempt and enforcement of orders versus actually going and getting child support for someone who clearly could afford their own lawyer. You mainly see it with enforcement of it.
Does HFS only deal with child support or other child support-related issues such as uncovered medical expenses, insurance, daycare, things like that?
The health insurance is big because when a child is on a medical card, we ask for health insurance to be provided by the other parent, the non-custodial parent. But what they say, though, is it's really only if it's available through employment and affordable, because it's unrealistic to order a person to provide health insurance all on their own, without it being available through their employment because of the cost. And, I don't know if that'll change.
Health insurance is ridiculously expensive, or can be.
Yeah, so I don't know if that'll change with Obamacare. But right now it's if the child's on a medical card, that is considered, assistance that you're receiving through HFS. And so we would look to file a petition. And a lot of times the parent might say, we have an agreement, he gives me X amount of money. That's fine, but he's still going to have to provide health insurance if it's available and affordable through an employer because the child's on a medical card. So we try to get kids off of medical cards. So that would be another thing that we're interested in.
What about uncovered medical expenses and daycare?
We always ask for them to pay half of uncovered medical. And then sometimes where there is some type of an agreement or we're intervening on an already existing order, they may have already ordered that person pay X amount of money a week for daycare, or X amount of money a week toward health insurance premiums, or they already have some type of arrearage on medical or daycare. And if it's ordered to be paid through the state disbursement unit, we can keep track of that. So then we can also intervene and help a person where there's a specific dollar amount ordered through the state disbursement unit for medical or daycare. Alimony, we do not do.
Okay. Another question. A child support order is entered in Texas. Mm-hmm. Dad, who is obligated to pay child support, moves to the state of Illinois. Mm-hmm. Mom continues to reside. Mom moves to Alabama. Does HFS ever get involved in attaching the assets of the father who is living in Illinois for purposes of providing the mother with child support?
There's a couple things that can be done. when a person, where you have an existing order in a state, if that mother and child still live in that state,
So Texas.
let's say Texas, so
Okay.
the child's in Texas with the mother, and the father moves to Illinois. Texas contacts Illinois and says, we want you to go after, collect child support for us from the father because he's now in Illinois.
Okay.
So what they do then is they send out what's called registration of foreign order, and they send that to the person in Illinois. They have X amount of days.
They would send that. Texas would send that to the dad.
Well, our Illinois will do it. HFS will do it. So
Okay.
Texas caseworker will send us the order. They'll send us all of this, their information. So I'm not a HFS caseworker, so I'm really sure what's required. But
Sure.
then what goes out is a letter to the non-custodial parent here in Rockford. And it'll say, there's a child support order in Texas. You are ordered to pay X amount of money, and you now owe blah, blah amount, and, you're still ordered to pay X amount every week. And if you are contesting to this and saying that this isn't true, you must respond, and it tells you how to do it and everything within X amount of days. If they don't, that order then registers in the state of Illinois for enforcement purposes only, which means that that's a done deal now. Many people will come to court and they'll say, I never knew my kid was in Texas. I never knew there was a child support order, da, 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 da. You have to go to Texas because Illinois only has the ability to enforce that order on the person.
I see.
They cannot change or modify the order. They'd have to go back to Texas to do so.
And so, how does the Attorney General get involved in enforcing that foreign order? What do they? What do they file? What do they do? What
So
do you
then,
do?
once the time limit is up, the first thing what we file is called a petition to determine arrearage, or a petition. No, I'm sorry. It'd be a petition for past due arrearage because it's already been established.
Okay.
So what it means is that we now just send notice. That's it. They don't have to be served. Even when for registering the order, it's just notice. Yeah.
And how do you find out their address?
The people from Texas are to provide it, or you'll do an employment verification, or we look at, where they're collecting their benefits and things like that. Rarely have I had a person not come to court on a registered order.
Okay.
But I'm sure it happens. The person's never receives it. But so then they come to court on that. You enter judgment on whatever Texas is saying he owes,
Okay.
and then you say, what can you pay toward it?
What do you mean by enter judgment?
Means that you enter an order saying, yes, this is what this person owes. So let's say the petition says there was an order entered in 1999 in the state of Texas for you to pay $50 a week towards the minor, Abigail Simpson, born blah, blah day. There has been no other child support orders entered since that time. As of March 24th, 2013, you owe $14,052 in past due child support. And then it'll say, that we request a prayer for relief, or we request the court to enter an order saying, yes, this is the amount that this person owes, and an amount of what they're going to pay, either the whole amount or payment of whatever, to pay toward it. If they don't agree to pay the whole amount and they're just going to pay X amount a week, then we ask them, do you have a job? What's the best case scenario would be that they do, and you can do a notice to withhold, and you'll come back in 3 months and see that clearly $25 is coming out every week toward this. You're done.
How did you attempt to figure out whether they have assets?
Mm-hmm.
A $100,000 bank account or something like that?
The AG, like me personally, no. I will look to see if they're collecting social. My system doesn't allow me to do that.
Okay.
So I can see.
So you don't file motions for discovery to determine that kind of stuff?
No. So what'll happen though is between HFS, my client, and Texas, they'll get that information. For example, once it's registered for enforcement in Illinois, depending on how much is owed and when was the last time they paid, this judgment can go off to multiple different units within HFS. So you have the driver's license unit.
Sure.
You have the lien enforcement unit. They're the ones that will look and talk about assets. They'll put a lien on your house. They can put a lien on your bank account. They can put a lien on your retirement account. They can put a lien on a money mortgage or a money market account.
So
they do that, yeah.
Driver's license unit, the Secretary of State. Explain that process, because I think many people would be interested in understanding that.
So what'll happen is if you are if you owe more than a certain amount of money, and I believe it's more than $3,000 or $5,000, one or the other, because I know I tried to send one, and they're like, well, his arrearage isn't big enough. So once it meets a certain amount, and they've gone a certain amount of time without paying anything, it then gets transferred to the driver's license unit. The driver's license unit will mail them out something. If they ignore that, that's terrible, because they want to work with you. They do not want to suspend your driver's license. But what most people do is they disregard the letter.
Or wait to the last minute.
Or they wait.
I've had people call me in those situations.
And they've waited too long. But if you contact the driver's license unit, that's the first thing you want to do. And you want to say to them, hey, here's my situation. This is what's going on. What can I do? And they'll try to work with you. Number one, they're going to ask you for some type of lump sum payment. That's what they're going to do. If this is your first time, then they're not going to ask for a lot of money. What they are going to ask is to show then a consistency of paying. So what the best thing to do would be to contact them. They're going to say, well, I need you to pay, money you don't have. Okay. So let's say they want you to pay $200. You can't do that. Well, then get your butt to start mailing, to the state disbursement unit and mail $25 a week, $25 a week, $25 a week, right? Do that, or every 3 days. Call them up again. Say, look, I've made 4 payments in a row of X amount of money, week, can you, if I can pay $100, $50, will you help me? And then the other one thing would be too, is if you're saying that the reason you can't pay is because your obligation is too great, they're going to say, well, you should file in court then.
Let's say the Secretary of State says, nope, you're not making the correct number of payments. We're going to suspend your license. Then what do they do?
Then what you do is your recourse is, and it'll tell you right on your paper, it'll tell you that you are objecting to this and you're requesting what's called an administrative review. Okay? And you gather up all your information as to what will help you to win your case. And you mail it to what's called the gathering unit. And it's right on there, the address and everything in Springfield.
Okay.
Now, your license will probably get suspended in the time that it'll take them to review your case.
So they don't stay the suspension of your license until the review has occurred?
They may, but I don't think so. I mean, I've had people that are in the process of reviewing it, and they lost their license. Or maybe they have to actually suspend your license first.
Okay.
I think they have to actually suspend your license first, and you then appeal it. You're objecting it, and you mail in your information. The thing that I notice works the best is that you file to reduce, because most of the time that's why you're not paying. You can't afford it.
When you say file to reduce, not with the Secretary of State, but in family court, correct?
Yeah. You file a petition to reduce in family court.
Okay.
You call them up and say, you know what? Yeah, I be very. I think that and I think this is true of life. The more ownership that you take for why you're in this situation, the better. Because all they listen to every day is people saying, I didn't know, and I didn't know, and I didn't do that, and they don't care. So you say, look, I didn't pay my child support. I mean, obviously you know if you did or you didn't, right?
Right.
And I didn't know, what to do, whatever. So now I filed to reduce. I'm looking for work. I can pay $5 a week until, this gets to court and I get, a job. And, can you hold off? And a lot of times, if it's the first time, they'll do a lot to work with you. But you know what they'll do is the minute you don't pay that $5 or the minute that you don't show up to court and your petition's just thrown out, they suspend your license. They're done.
How do they know when you haven't shown up to court and your petition to reduce has been dismissed?
Our system is called GUI. And every time I go to court, I bring back all my files. My secretary puts in notes in GUI.
Okay.
Those notes are able to be viewed by every single unit within HFS. So they know what's going on in court. They know what's going on with the driver's license unit. They know if they're doing it correctly, which is why lawyers will call me and they'll say, hey, Maureen, can you tell me what's going on with my guy. You know, he lost his driver's license. And I can look in there, and it'll tell me every time he called the driver's license unit, what the driver's license unit told him he needed to do, you know, and so on. Now, not every worker puts in notes every single time, which, I mean, the best case scenario is I can even read notes when they just walked into the public aid office and were at the window and said, blah, blah, blah. They're supposed to write that in there so that we all know. So we know when people are cooperating and when they're not.
So all of this that you've talked about is related to child support enforcement or obtaining child support or reducing child support in family court. Anything that we've missed in regards to that?
Well, just one thing, because I think driver's license are a big thing. I get a lot of people ask me, Maureen, please help me get my driver's license. And I think that part of the system that stinks is that people aren't willing to help people that aren't filling up to their obligations. They don't care that they've lost their job. They don't care that they were in prison. They don't care. And the other thing is the law doesn't care either. And I think a huge thing that person has to know is that they have to do this themselves. They are the ones who must take responsibility for this. They are the ones that have the child. They're the ones that are to take care of this child, not the state of Illinois, not the Attorney General's office. So when you get yourself in a situation where you can't take care of your child, that's not what you're being judged about. What you need to do then is to follow through with what you need to do then to fix this situation. So if I'm going to prison, I file immediately to say I'm going to prison. You get out of prison and you go to court and say, the reason why I owe $10,000 is because I've been in jail 8 years. The law doesn't allow you to modify your child support back 8 years. You cannot do that.
I have seen that time and time again where potential clients have called me and said, Brad, I was in prison for 4 years. Now I'm out. They're saying I owe $20,000 in child support, but I was in prison that whole time. How did they expect me to pay it?
Right.
And I've said, was there a child support order? Yes. Did you modify that child support order? No.
Right.
Well, then you're kind of up a creek.
Right. And I think a lot of people say, I didn't know that. So if anything, the thing I would want people to know is that we can only change your child support obligation from the day you file. If that dad says to you, you don't have to pay child support, don't worry about it, or the mom tells you that,
Yep.
you then file immediately in court and get that in writing. You get a court order that says, due to whatever these circumstances are, you're not paying child support anymore. Because it doesn't matter what that person says. Unless there's a court order to it, you're stuck paying. So you say 10 years ago, well, she told me 10 years ago that if I never came over and tried to see my child, I wouldn't have to pay child support. Well, there's no court order. The court order is still there that you pay. You owe it, period. The court is not going to help you with that.
So basically, if the mom who has custody says you don't have to pay child support, you need to file a petition to terminate child support.
Correct.
Have her come into court and make that statement to the judge, and then get that in a court order.
Right.
So the judge stops child support.
Right. And another thing people, if you're not a lawyer, don't understand is they think they've done it because they'll take her to public aid. They'll take her to HFS. And HFS will say, okay, and they'll close her case, right? They're canceling. She doesn't want their services anymore. They're closing the case with her. That's great. Child support isn't going after you anymore. But there's still a court order.
Right.
So she could get a lawyer 5 years from now, right? Because she needs money, bring it back to court, and you owe that money. Doesn't matter what child support said to you. There's a court order. So you have to get another court order that terminates it. Because I've seen that too. And I say, yeah, we don't care. We're not going after you. But that doesn't mean you don't owe her. If you still have a court order, you never changed or modified or terminated.
That could get someone out of being held in contempt, though, correct?
Yes.
So if the custodial parent says to the visiting parent, you don't have to pay child support, he stops paying child support, then his behavior is not on purpose.
Right, it's not willful.
It's not willful. Mm-hmm. And so, but that doesn't solve the problem of maybe 3 years of an arrearage with statutory interest.
Right, that you have to pay him.
What is the interest, by the way?
It's 9%. So if you want to know, this is the part that people get confused on, though. So when they get their paper that shows what they owe, it's not 9% of the whole thing because you don't get interest for interest. So they'll separate it out for you. This is what your unpaid child support is. This is what your interest is.
It's 9% per year.
Yes, it's 9% a year. So you take the unpaid child support amount. So let's say you owe 5 total. 2 of it is unpaid child support. 3 of it is interest. Only look at the 2, and you take 2,000 and you multiply it by 0.09, and that'll give you what you owe a year. And then a lot of times I'll divide that by 52 weeks to see, hey, dude, I know you only want to pay $5 a week for the interest, but you really should pay 6 or 7 because you're not even covering the interest.
Right.
So that's how you figure out if you're, because they'll say, I've been paying for 9 years. And I say, yeah, but it's going up because you're not paying enough.
Yeah, I mean, I see court orders all the time where you've got $15 a week towards an arrearage. Well, if the arrearage is $20,000, you're not digging yourself out of the hole at all.
Correct. Right. So you want to, but don't lump it together with the interest because, and the nice thing is every time you pay toward your arrearage, it goes towards the principal first. So they bring down the principal first. So it's not collecting that. The 9% is less and less.
Yeah,
so that's nice.
Is interest calculated on the interest?
Right. No.
Oh, okay.
Right. So it's separated out. So if I owe 5 and 3 of its interest, only take 9% of the 2, the principal. So then, and when you pay your arrearage, it all goes to principal. Doesn't go to, they just changed that. They just changed that law a couple years ago. That none of the arrearage goes towards your interest. It goes to your principal since that's not collecting any interest. So now your 9%, of the amount is getting lower and lower and lower.
Outside of child support and child support related issues, does the Attorney General assist people in any other manner?
Not individuals.
Okay.
No, the rest we do is strictly to recoup money for the state of Illinois. We're like a giant debt collector. That's how we look at ourselves.
Is there anything in relationship to Social Security disability?
Well, the thing that's important to know about Social Security and unemployment benefits that I always like to tell people, if you've worked and you do not qualify for unemployment, go again, okay? Because a few months can make a big difference and you can qualify for unemployment. So the best place to go is right across the street from the Coronado, the Illinois Department of Employment, and they will help you to see if you qualify for unemployment.
In Rockford, correct?
Yep, in Rockford. And the second thing is that always, always, always tell them that you have children. Regardless of whether or not the children live with you, you may be eligible for what's called the dependency allotment. The dependency allotment is additional money that you get from unemployment to take care of your children. Now, the only time you wouldn't get it is if the custodial parent is collecting unemployment and getting the dependency allotment.
I see.
Otherwise, you get it. So they'll say, well, but that kid doesn't live with me. They don't have to live with you to get the dependency allotment. So if my unemployment benefits are $250 and 50 of it is the dependency allotment, that will be your child support obligation. And then the rest of it you'll get for yourself, which is the money that you're getting anyway because you have a child. So that's what that. Social Security now, there's 3 types of Social Security that we deal with.
Okay.
There's SSI. SSI is where you are mentally, you are unable to ever work.
What does SSI stand for?
It's like Social Security. That's a good question. I'm not sure with IOS. But this is where you'll see, like if you have you'll see it, that they'll get it their whole lives.
Okay.
So they are mentally challenged.
Sure.
They were in like some horrible car accident and now they're disabled in a way that they can never ever work. They'll collect what's called SSI. And
the Attorney General's office assists people with obtaining those monies. Is that right?
No.
Okay.
HFS does.
Okay.
Well, actually, no, they don't. Social Security does that.
Okay.
That's all strictly Social Security.
So your office doesn't specifically assist with that.
No.
But HFS does.
No, they don't either. Sorry about that.
They don't.
No.
Okay.
That's all Social Security. The only reason we care about it is that if your only source of income is SSI, that cannot be used as income for child support, and your child support obligation should be 0, okay, unless you have other income. So there are people out there collecting SSI, and they have a child support order.
I had a call in specifically about this issue. So if someone is receiving SSI, they're not obligated to pay any kind of child support whatsoever?
That's right.
What if they're not completely disabled?
Then if they can work, then that's part of how they get SSI though. Like I believe and when the system works correctly, that they are reporting, because sometimes, like I had one where this kid, I think he was like 8 years old, he was collecting SSI. Well, when he turned 25, he was no longer collecting SSI. And I think I think each year there's a review to determine whether or not this person can actually work. And, and if they can, then they're ordered to work, and then it affects their SSI benefits.
Well, the judge, okay, here's a scenario. Someone's receiving SSI. They're receiving $700 a month in SSI. Mm-hmm. That money, I think what you're saying, is not subject to the child support calculation under Section 505
Correct.
of the IMDMA. However, will the judge take into account their ability to work, say, at McDonald's, even though they can't be a teacher?
No.
And why is that?
No. Because where a person's collecting SSI, and that's their only source of income, it's already been determined by Social Security that this person cannot work.
I see. Well, then why are they only receiving $700 a month or something? I mean, I'm obviously pulling that out of the air, but I've seen SSI payments before. It's not like you're getting $3,000 a month or something like that.
Right. Well, because that's what they're getting in cash.
I see. And they're receiving other forms of assistance.
Correct. Oh, yeah. Like I'm sure they have a medical card.
I see.
I'm sure they get food stamps. I'm sure they probably qualify for free or subsidized housing. They don't pay any of their utilities. I mean, that $700 is strictly money for them to, most of the time, pay for whatever they want. The other thing is that's all the government we've got.
I see. So if a person has been determined to be able to receive SSI, they are not going to have a child support obligation.
Correct. And what we do instead is we put in there that based on the fact that they are without income, they're unemployed and without income, and their only source of income is SSI, that their child support obligation is zero. However, if they ever get a job or their income changes, they must notify HFS and the petitioner, the custodial parent, within 7 days of that changing.
Does the custodial parent have any recourse to obtain some kind of state assistance then? Because they're not receiving child support anymore.
Right. So they, just like anyone, can go and, apply for public aid and see if they qualify. But
that would be based on their income. Correct?
Right. Because whether or not you get child support or you don't, the person receiving it, it's income that they have to report, as income. But like, for example, I'm an individual with a child who receives no child support at all. And most likely, if I were to go after that person for child support, they probably would not have to pay because they are disabled. They went to Iraq and they are collecting state veterans benefits. Like, I would think they would say he's not employable.
Sure.
And so then what is my recourse? Well, it's not to... My only recourse would be if ever he did... I mean...
If he for some reason situations would change where he wasn't deemed by the government to be disabled, then you can collect child support.
Yeah, then I would, right. And I mean, I guess in a great world where we don't have such humongous... I mean... If you ask an individual, how long does it take for me to ask HFS to get child support for me, and they actually start, if they ever actually start getting it, you're looking at a year because there are so many people.
Right.
So in a perfect world where you don't have that many, we could actually keep tabs on, let's say, this person who's collecting SSI, right? And we could actually have them come to court periodically and show proof from their doctor and whatever other proof that they give Social Security, right, to show that, yes, I am still disabled, right? And that kind. And we try to do that, like with ones that are appealing their disability cases.
Sure.
And things. But I mean, right now, I have thousands of cases. So it's like, and instead, they show proof they're on SSI. We say, well, obviously Social Security is deemed you can't work. So if it ever changes, you have to notify us. But then SSA and SSD are the other two types.
Okay.
And I, again, do not know what that stands for or why you get one or the other. I know that SSD is Social Security Disability. I know that.
Okay.
That's what that is. Both, one or the other, and I'm not sure which, or both, your child may qualify for what's called a dependency allotment, which is out just like unemployment benefits. It's outside what you're going to receive from disability.
So if you didn't have a kid, you wouldn't be receiving it.
Correct.
But you don't have to be the custodial parent
Correct.
in order to get it.
Right. And if the child doesn't live with you, it automatically gets mailed to the parent who does.
Huh.
So they'll get, like I have one where there are two kids and she gets $240 a month for each child. So where you look at the person's entire benefits they're getting, and if I were to take 28% of that, and it is $210, well then what she's receiving satisfies his child support obligation. So that's what it is. We don't take additional money out of his social or her Social Security.
I see.
And you'll see this a lot. There'll be a child support order for $50 a week, let's say, okay? And the guy's working, loses his job, okay, starts collecting SSA, SSD, does the right thing, tells Social Security, I've got kids, here's where they live. The kids start getting the Social Security dependency allotment, okay?
Which could be $150 a week.
Yeah. If that amount that they're getting is more than that court-ordered $50,
He has a surplus?
no. His child support obligation's been satisfied, okay?
Sure.
However, HFS has no idea, okay? We're not Social Security, so we don't know that mom's getting a dependency allotment, right?
Right.
So we're going to keep collecting the $50. So we're going to take his taxes. We're going to put a lien on his bank account. We're going to, oh, guess what? He got a little side job because he's not completely disabled.
Because he thinks he doesn't have to pay anymore.
Right, and we'll just take it. And meanwhile, the $50 a week, court order, it's still going. You have to file in court to say, hey, I shouldn't have to pay any more child support because my kids are now getting this Social Security dependency allotment. However, the law is nice in that we will say that your child support obligation ended when, they started getting...
But wait, Maureen, he is paying his child support. And he's paying it right to her. The money is going right to her. Why doesn't that constitute his child support payment so there can be a recalculation? He's actually giving a surplus based on the court order.
He needs to go to court, though, to fix that. Or he needs to go into public aid and say, hey, you guys are still taking money out of my paycheck here, and my kids are getting a dependency allotment. And we say, oh, okay, well, you need to let us know this because we don't know. And then they will put in their system that this satisfies his obligation, and they'll end it. But like any other court order, right, technically, it's still accruing in court.
Right.
And she could go to court. Now, would she win? No. Would the court say, hey, you know what, this man's obligation ended when your kids started getting the dependency allotment? But it's a big mess, right?
Sure.
It's a big, and how much money have you lost? Right?
And probably the original court order, like you said previously, says the money, the $50 a week, has to go to the state disbursement
Goes to
unit.
the state disbursement unit.
Whereas the money was going directly to her.
So it could be seen as a gift, right? Some
Sure.
case scenarios. So it's best is the minute you qualify for Social Security that you tell HFS and you file to terminate your child support obligation saying, hey, guess what? My kids are getting Social Security. So that your obligation now is strictly through that.
Another question. There is a guy who was the visiting parent. He dies. Mm-hmm. He has a $30,000 arrearage. He's got money associated with his estate. Maybe a house, maybe a pension, something along those lines. Does the Attorney General's office ever get involved in those situations to get money back to the custodial parent?
That is
Or to the state?
excellent question. Our office does not do that. And is there something, right, that says your child support obligation dies with you? Or is it a claim, like any other claim? I know for one thing, if you're going to try to file for bankruptcy to get rid of your child support obligation, that is not subject to bankruptcy, okay?
Right.
So your child support arrearage is like, and the other thing is, I do believe that you can file a claim. Yeah, actually, I think this is what happens. HFS does not do that.
But doesn't HFS want to collect that money? Don't they want that money to
No.
go back to the state?
Well, what they do then is, which I don't know how this helps anyone, but what they do is where it's money owed to Illinois, then yes, we would file a claim in their estate for the money that's owed to the state of Illinois. And yes, we do that.
Okay.
If it's
So,
money,
and
though,
money owed to the state of Illinois would be the custodial parent is receiving assistance, therefore the state of Illinois is owed money, not the custodial parent.
Right. But where's the custodial parent? The money is only owed to them. When that person dies, we just zero our case out. It's closed. Okay. They would file a claim, though, in that person's estate, asking for the money, and they are a higher. Illinois is a 6th class claimant. Child support is 1st class claim.
Okay.
So she would get all her money first before we would get ours, but she would have to do it on her own. We would not help her with that. She'd have to file her own claim.
And what do you mean by claims?
When a person dies, by law, the executor or the administrator, depending on if you died with or without a will, that executor or administrator has to send out notification to every possible creditor that this dead person has. Meaning, Mom, I owed you child support. Illinois, my kids were on a medical card. Bergner's, I have a credit card with you, and so on and so on. Those claims are all classified under certain sections. So, money you owe to the bank, taxes, the IRS, they are like 2nd class claim.
Okay.
Child support is a 1st class, meaning that money gets paid first. So if let's say I die and I have $10,000 and I owe $10,000 in child support, and that's my only 1st class claim, she gets the entire 10 grand, the rest of us get nothing. So it's divided up, it trickles down as each claim. Illinois, for our purposes, for medical, which is usually what we're going after, is unpaid medical that Illinois is paid for you.
Sure.
Is 6. We're 6 down the line. So lawyers' fees, you guys.
We're like 39th.
No, you get paid first.
Wow.
Yes, lawyers' fees are first. Taxes is big too. Taxes is up there. Money owed to banks is up there. But credit cards are even lower than we are. Credit cards, that kind of debt. I think like your mortgage.
But you guys are at 6.
We are
6th
6.
place.
Mm-hmm.
Okay.
Yep. And so then we will file a claim, and depending on the claim, as an individual, you have like 2 years to file once you've been notified that someone's died and there's an estate out there.
Okay.
And you are a possible creditor. You have like 2 years to file, I think, a claim. We do not. We have a very short amount of time. I don't remember how long it is, but it's not
Pretty
that
short.
long. Mm-hmm. Yeah.
Well, this has been very informative. Any other issues, any other ways where the Attorney General's office gets involved with any child support, financial related issues?
The only other one would be where an individual has filed for disability and they were denied and are now appealing it. We represent the state of Illinois on the appeal. And what we're doing is, I think the big thing that's difficult for people to understand is the difference between court and administrative stuff. So most of the stuff that HFS is doing is all administrative, which means that if you file in court about it, their court can't do anything for you. The court isn't the one who's done it. You have to do it administratively, meaning you have to do it with HFS. Driver's license is a perfect example. The court didn't suspend your driver's license. The court can't give it back to you. HFS, through a certain division, took your license, and that's who you have to work with. So we call that administrative appeals, administrative reviews, go administrative. Now, once you've done that, right, and you don't like the answer, now you file in court. And that's a totally different courtroom. That's Prochaska, and in Winnebago, it's Prochaska and
Judge Doherty.
And Doherty. They're the ones that are handling now. I didn't like my answer. Okay, I've exhausted my administrative remedies, and I didn't like the answer, and now I'm appealing. They are the ones who hear that, and we would represent the department, HFS, on whatever is being appealed. Depends. We just do a certain kind.
Top 3 things you would tell a mom who is desperately in need of child support and needs the assistance of public aid. What would you tell them?
That I would go there personally.
Okay.
Anyone who's called
as opposed to calling.
Right. Anyone who's called that 1-800 number knows that it's ridiculously hard. The best bet would be that if I had transportation and I could get there, that I would go in there physically. And I know anyone from HFS right now is like punching me in the face because they don't want that. But really, if I am desperate and I need help, they're so good down there, and they would, so you would go in there personally.
Sure.
If you cannot, then getting to the library and getting online and doing it online. Setting up an account, emailing them, and doing it through that is the second best way to get, through to them and get your stuff. And then you just have to be patient, but super, super cooperative.
And where is the HFS office located in Rockford?
It's on Taylor Street, which is right off of Avon. So if I take Auburn Street, okay, it's Auburn, and I take a left on Avon. Okay. If I'm coming from North Main Street, if I'm coming from Auburn High School, yep, I would take a right on Avon. It's right by where the driver's license place used to be, and the Gray's. There's an IGA there, little strip mall. Avon, it's like right before there, or right after if I'm coming from Auburn High School. You take a right on Avon, and then it's right there on the corner. Because Avon, the next street when I'm on Avon is Taylor. So it's right there on the corner of Avon and Taylor. It's a brown building. The next block up is DHS.
Okay.
Which is the Department of Health and Health Service. DHS is the Department of Health Services. Okay. We're the one right before that.
Great.
So they're right there. So if you're coming from North Main, you go left on Avon from Auburn.
Well, Maureen, thank you for your time this evening. I appreciate it,
You're
and
welcome.
I'm sure our audience does as well. These kinds of issues are complicated. I see you in court all the time with stacks and stacks and stacks and stacks of files helping people get child support. And I know that the information provided today will help a lot of people when it comes to knowing how the process works.
Well, good. Well, thank you, and thank you for having me, Brad. I really appreciate it.
Thanks, Maureen.
You just heard a phenomenal episode of Divorce Talk Radio. Listen to Divorce Talk Radio live on RockfordCollegeRadio.com, Tuesday evenings at 8 p.m. To hear more of Divorce Talk Radio shows, please visit RockfordCollegeRadio.com. To learn more information about attorney Brad Tengler, please visit TenglerLaw.com.